Hey, good afternoon, everyone. We're going to go ahead and get started. Does anyone have any questions before we go on the record? Um,
Don't think
I
so.
do. Great. Doesn't look like we have any questions, so we're going to go ahead and get started. We are opening the record for the hearing in the appeal of Metro Mortgage Group LLC, Office of Tax Appeals, case number 2307-13826. Today's date is September 18th, 2024, and the time is approximately 1:56 p.m. My name is Judge Ralston, and I'm the administrative law judge who will be conducting the hearing for this case. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by tax experts and is independent of any tax agency, including the Franchise Tax Board or FTB. As I mentioned, this hearing is being live streamed to the public and is also being recorded. So we ask that so the transcript and the video recording are part of the public record and will be posted on our website. So we ask that you don't use the chat function and also don't show any sensitive information on the screen. Also present is our stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everyone speaks one at a time and does not speak over one another. Even if you think you know what I'm going to ask, please let me finish my question so we can get a clean transcript. Also, please speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. We held the pre-hearing conference in this matter on August 26, 2024, and appellants submitted exhibits labeled 1 through 5. Yes, appellant initially submitted exhibits labeled 1 through 5. And the respondent FTB did not have any objections to appellant's exhibits 1 through 5. So we're going to admit appellant's exhibits 1 through 5 are admitted without objection. So respondent, or is that still the case? Ms. Peters, you had just the exhibits 1 through 5?
No, I then submitted additional exhibits before the deadline that were acknowledged.
Let me just double check that. Okay. Oh, right. Oh, okay, I have them. So you have exhibits 1 through 10.
Correct.
Yes, okay, that is right. I do have those and have reviewed them. So let me just check with FTB. Did you receive the appellant's exhibits 6 through 10?
Yes, we received them.
And did you have any objections?
No objections.
Okay, so appellant's exhibits 1 through 10 are admitted without objection. And then we had a respondent submitted exhibits A through M. Ms. Peters, did you receive a respondent's exhibit M?
Was that an additional exhibit?
Yes, that was an additional exhibit that was also submitted before the deadline.
I did not receive that.
It was labeled comment details. Um,
That was not forwarded to me.
okay. Then we're going to take a few minutes, take a few minute break so we can FTB, are you able to forward that exhibit to Ms. Peters?
Yes, I can forward it. Just give me a couple minutes.
Okay, so we're gonna take a break for about 5 minutes to give you time to get that exhibit and take a look at it. And then we'll come back on the record. So the live stream will continue. So please make sure that your audio and video are muted. And we'll come back in. It's my clock says exactly 2 o'clock, so we'll come back at 2:05. Okay, looks like everyone is back, and we are back on the record. Ms. Peters, did you receive that Exhibit M?
I did.
Okay, and did you have a chance to take a look at it?
Yeah, it's pretty brief and I have no objection.
Okay, thank you. Actually, let me back up a little bit. Can I have the parties introduce themselves and who they represent for the record, starting with Ms. Peters?
Yes, Darrell Peters. I am the managing member of Metro Mortgage Group LLC. And
Thank
I
you.
represent me, myself, and I.
Thank you. And then for respondent.
Alyssa Pinnerbossi for the Franchise Tax Board.
Thank you.
My name is Topher Tuttle, representing Franchise Tax Board.
Okay, thank you. So back to the exhibits. We have FTB has submitted exhibits A through M, and there are no objections. So we are going to admit respondents exhibits A through M are admitted without objection. So at the pre-hearing conference in this matter, Ms. Peters, we talked about you may be testifying under oath. Did you want to testify under oath or did you want to just present your statement today?
I think I'll just present my statement. I don't see any need to testify.
Okay, and you had no other witnesses?
No.
Okay, thank you. And Ms. Pinnerbossi, you also had no witnesses?
Correct.
Okay, thank you. So the appellant has asked for 20 minutes to present their case. The respondent will have 20 minutes to present their case, and then the appellant will have 5 minutes for a rebuttal. I may ask questions at any time. And did anyone have any questions before we begin?
No.
Looks like there are no questions. So Ms. Peters, begin. You have 20 minutes.
All right. So before hiring a remote limited engagement clerical assistant who is personally based in California, we reviewed the California statutes relating to hiring such an employee, relying on the information provided by the FTB on their website as it relates to doing business in California. Exhibits 1 and 2 illustrate that information. Given that Metro Mortgage Group LLC is not licensed to conduct its core business and only income-producing activity, namely brokering mortgages in the state of California, has no property in California, and the payroll for the employee in question is well under the compensation threshold, the company determined and has shown that it does not meet the sales, property, or compensation thresholds under Code Section 23101B. We also concede that Metro Mortgage Group LLC is not in the business of selling personal tangible property and is therefore not protected under Public Law 86-272. We're left with Section 23101A, which defines doing business as actively engaging in any transaction for the purpose of financial or pecuniary gain or profit in California. The question is whether this section of code applies to Metro Mortgage Group LLC and our limited engagement California-based clerical assistant. Our ongoing interactions with the FTB have frankly been much like a game of whack-a-mole, as we argued that in our case, there is no transaction for financial or pecuniary gain in the case of our limited engagement California-based employee. The FTB has responded with an ever-changing list of justifications for classifying Metro Mortgage Group LLC as doing business in California. Before addressing these various changing arguments forwarded by the FTB, it's important to present the specific federal regulations that limit and define the activities of Metro Mortgage Group LLC and our employees. The very nature of the mortgage brokerage business is regulated by the CFPB, the federal agency overseeing mortgage brokers and their licensing. These regulations preclude us from engaging in any transaction for the purpose of financial gain or profit in any state in which the business and its mortgage brokers are not licensed by the state agency responsible for such licensing. Metro Mortgage Group is only licensed in Colorado and Vermont and is legally excluded from conducting our business in California. In addition, our limited engagement employee who resides in California is not licensed to originate mortgages by the CFPB, NMLS, or any state agency, and can therefore not engage in any activity that contributes to originating mortgages. The CFPB regulation 1008.103E4 clearly states that an individual who performs only purely administrative or clerical tasks on behalf of a loan originator is exempt from licensing. Exhibit 6 shows that statute. Our assistant's clerical duties include such tasks as organizing our electronic files throughout the year and can hardly be construed as contributing to a transaction for the purpose of financial gain or profit. Metro Mortgage Group is only licensed in Colorado and Vermont and is therefore prohibited from engaging in brokering mortgages in California. And as an unlicensed individual, the limited scope employee can legally only perform clerical tasks. When examining the various arguments presented by the FTB, it's important to understand these federal limitations placed on Metro Mortgage Group's remote limited engagement clerical assistant. Let's examine the arguments presented by the FTB in their opening brief. Exhibit 5. All of the precedential cases cited examine the nature of transactions engaged in by the company or employee for financial gain or profit. These cases all involve profit or income-driven activities, whether they resulted in actual profit. None of these cases involve the determination that simply having a California-based employee is de facto a transaction for financial gain or profit. And while not a legal argument, good sense would dictate that simply paying an employee is not what is meant by actively engaging in a transaction for financial or pecuniary gain or profit. This case is cited, the appeal of Knoll Pharmaceutical. I included in Exhibit 7. This case specifically involves a stock of goods owned by Knoll Pharmaceutical and maintained in California, for which they received benefits and protection, as well as having detail men based in California who were directly involved in orders and processing inventory. There was emphasis given to the benefit and protection given to the goods owned by the appellant and maintained in California. Metro Mortgage Group LLC has no goods, property, or assets in California that derive benefit and protection from the state. And we have no employees directly involved in our product, which is brokering mortgages. In Hayes v. McColgan, this is a case of a liquidator who is given broad powers with respect to the California businesses or corporations being liquidated, including access to all business, property, and assets in California. Again, Metro Mortgage Group has no business, assets, or property in California. In the case of Kagan Homes, Exhibit 9, this is a case where the transactions in question are purchases and sales of stock in the company. Again, these transactions have the express purpose of financial gain or profit. In each of these cases, there were actual active business transactions, which were determined to be the transactions, that qualify the business as doing business in California. None of these cases involved a company with no active business transaction or physical presence in California who employed a single remote clerical worker not involved in any of the company's actual business transactions. Metro Mortgage Group is legally precluded from any business transaction whatsoever in California based on federal licensing requirements. In addition, there is no action or task our limited engagement-based employee can legally undertake that would contribute in any way to a business transaction for financial gain or profit. None of these cited cases support the determination that simply having a California-based employee establishes a physical presence in California, or that we were actively engaged in a transaction for the purpose of financial gain in California under Section 23101A. Turning to the non-precedential appeal by Profarma Sales, Exhibit 10, which the FTB uses to support the idea that simply having a single California-based employee determines that a company is doing business in California. In this appeal, the FTB cites California employee met the activity requirement required under Section 23101A simply because the taxpayer had a physical presence in California. However, the following material facts differentiate this non-precedential ruling from the current matter. First and foremost, the pro forma sales case hinges on a filed federal Form 941, which listed a California address for the company. In this case, listing a California business address established a physical business presence and nexus. The ruling itself states, California employee met the activity required under 23101A simply because the taxpayer had a physical presence in California. The ruling does not state that the company met the activity required simply because the taxpayer had a California-based employee. Metro Mortgage Group LLC has never listed a California address in any filing or form, federal or state, and has never had a physical business presence in California, making this case irrelevant to the question at hand. It is also important to note that when considering the appeal of pro forma sales, the OTA itself explicitly inquired about the specific activity of the employee. I quote, Office of Tax Appeals requested additional briefing from the parties. In particular, OTA requested that appellant describe the activities it performed in California during the 2014 tax year, including the activities, if any, performed at its Aliso Viejo, California address per its federal fourth quarter Form 941 and by its California employees at that address or elsewhere in the state. In this case, the appellant didn't respond to the OTA's request. The very fact that the OTA inquired about the activities pro forma sales and its employee performed in California explicitly implies that the activity itself is a factor in determining whether a company is doing business in California. If simply having an employee who lives in California were sufficient to determine that a company is doing business in California, the inquiry about the actual activities performed by the company and employee would be irrelevant, and the OTA would not have inquired about those activities. In this present appeal, the limited clerical nature of the activities performed by our employee who lives in California, and the fact that there has never been a California location or address for Metro Mortgage Group LLC support the determination that Metro Mortgage Group has not actively engaged in any transaction for the purpose of financial gain or profit in California and is therefore not doing business in California. To summarize, Metro Mortgage Group LLC is not legally licensed to do business in California. Our limited engagement clerical assistant who lives in California is not licensed to originate mortgages and is not allowed to perform anything other than clerical or administrative activities for Metro Mortgage Group LLC as federally regulated by the CFPB. All of the precedential cases cited by the FPB involve the company owners or employees actively engaging in actual business transactions for gain or profit in California. None of these cases define business transactions as the simple act of paying an employee. The non-precedential appeal of pro forma hinge on the company having a physical business location and presence in California. Metro Mortgage Group does not and never has had a physical presence in California. And finally, the limited activities as regulated by the CFPB that the clerical assistant can perform do not and cannot contribute to any of the company's business transactions. We believe that we've shown clearly that Metro Mortgage Group LLC does not qualify as doing business in California under Section 23101A. We ask that the OTA rule that 1, the appellant does not owe the annual limited liability tax for the 2019 tax year. 2, the appellant has established a basis to abate the delinquent filing penalty. 3, the appellant has established a basis to abate the ban penalty. And 4, the appellant has established a basis to abate the filing enforcement fee. Let me conclude also by saying that as a business owner, the process and attempts to gain clarity with the FTB have often appeared arbitrary and capricious. I finally undertook the expense of hiring an attorney to help me navigate this dialogue, and their experience was equally arbitrary and ever-changing. If their stance is that the simple choice to pay anyone any amount for any activity who lives in California de facto means that the company is doing business in California. The FTB should clearly state that on their website, and then the information they provide to businesses to help them determine whether they are doing business in California and are required to file California tax returns and pay the annual franchise tax. The total lack of disclosure and publication is arbitrary and unfair to any business attempting to make informed business decisions. And finally, anyone I've shared my experience with, be they business owners or other legal professionals, has discouraged me from pursuing this appeal because the overwhelming experience has been that the FTB is a powerful agency that does not engage in any real dialogue, and that no one ever wins an appeal against them, regardless of the circumstances and facts. They all suggest I should just pay the $800 a year since there is no hope in fighting for an appeal. However, this has become a matter of principle for me, to stand up for what is clearly a correct decision about my business, even though I am up against a Goliath of a state agency. Thank you, Your Honor, for your time and your unbiased consideration.
Okay, thank you. We're going to turn to FTB now. You have 20 minutes for your presentation. Please begin when you're ready.
Good afternoon. I, along with my co-counsel Topher Tuttle, are representing the Franchise Tax Board. The issues in this appeal are whether appellant owes the annual limited liability company, or LLC, tax, and whether appellant has established a basis to abate the delinquent filing penalty, the demand penalty, and the filing enforcement fee. First, I will discuss whether appellant owes the LLC tax. Every LLC is required to pay an annual minimum tax to California of $800 and file a return if it is doing business in California within the definition of Revenue and Taxation Code Section 23101. Notably, California's statutory authority to assert nexus under Section 23101 is coextensive with the United States Constitution. In the Presidential Opinion, Appeal of GEF Operating, Inc., your office found that Section 23101 included two alternative tests to determine whether a taxpayer is doing business in California. The first test is found in subsection A and states that a taxpayer is doing business if it is actively engaging in any transaction for the purpose of financial or pecuniary gain or profit in California. The second test is found in subsection B and includes a list of specific conditions which, if satisfied, will establish a taxpayer is doing business in California. Appeal of GEF specifically states that these conditions are not minimum thresholds and do not provide any safe harbor from the general definition of doing business in subsection A. FTB agrees that appellant does not satisfy any of the conditions in subsection B for doing business. However, as your office stated in Appeal of GEF, this does not prevent FTB from finding appellant is doing business under subsection A. In this case, FTB received information from the Employment Development Department that appellant had an employee in California during the 2019 tax year. Appellant has not denied that it had an employee in California during this time period, and this activity clearly meets the definition of subsection A. Simply stated, appellant actively engaged in a transaction in California by hiring a California resident. This transaction was for the purpose of financial or pecuniary gain or profit because hiring employees furthers appellant's business and is therefore motivated by profit or gain. While the hiring of a California employee clearly meets the plain language test in subsection A, I will also discuss various findings of your office's predecessor, the Board of Equalization, or BOE, when interpreting the language of subsection A. In Appeal of Knoll Pharmaceutical, the BOE found that a taxpayer does not need to be engaged in a regular course of business. Instead, the inquiry was only whether the state had provided anything for which it can ask return. In Appeal of Kagan Homes, the BOE found that one single profit-motivated transaction is enough to be doing business in California. The transaction does not need to result in any actual profit, as long as it was in the furtherance of financial or pecuniary gain. Applying these findings to this case further solidifies the finding that appellant was doing business in California. Appellant argues that its only activity in California was hiring an employee to do light administrative work, and the employee's work did not result in any actual business in California. However, as little as one transaction can meet the test in subsection A, and that transaction does not need to actually result in profit. Therefore, it is immaterial whether the tasks performed by the employee directly resulted in appellant's financial gain. Lastly, I will discuss the non-precedential case, Appeal of Recruiting Partners GP. In this case, the BOE found that a taxpayer whose only California activity was employing a California resident that it paid $196 in wages for the tax year at issue was doing business under subsection A. While this non-precedential case is not binding, pursuant to Microsoft Corp v. Franchise Tax Board, it is informative and can be looked to when determining how to apply the law. In conclusion, appellant was doing business under subsection A because the plain language of the statute indicates it was. The BOE has previously found that a taxpayer engaging in even one single transaction that did not result in profit is doing business, and the BOE and your office have on multiple occasions found that taxpayers with a single employee in California are doing business in California. Next, I will discuss whether appellant has established a basis to abate the late filing penalty and the demand penalty. Both the late filing and demand penalties were properly imposed because appellant failed to timely file a tax return by the due date and failed to do so upon notice and demand by FTB. Appellant has not alleged error in the imposition or calculation of the penalties, only that it did not have a filing requirement. Even if a taxpayer is unaware of a filing requirement, ignorance of the law is not an excuse for failing to file a timely return or failing to file a return upon notice and demand. As such, appellant has not established reasonable cause to abate either the late filing penalty or the demand penalty. Finally, I will discuss the filing enforcement fee. FTB notified appellant it had a filing requirement, and appellant failed to file a return by the prescribed due date. As such, FTB properly imposed the filing enforcement fee. Once the filing enforcement fee is properly imposed, there is no provision that excuses the imposition of the fee. As such, appellant has failed to establish a basis to abate the filing enforcement fee. Therefore, based on the facts and evidence in the record, FTB respectfully requests you sustain its position. I'm happy to address any questions you may have.
Thank you. Ms. Peters, you have 5 minutes for rebuttal, if you'd like. Ms. Peters, your microphone is muted.
Apologies. I think in my presentation, I addressed the issues relating to all of the cases cited by the FTB, and really have nothing further to add unless you have questions of me.
Thank you. I do have one question. So when you say that the employee in California engaged in like clerical and administrative acts, like do you have some examples of things that the employee would do?
Yeah, so most of their work literally was, I have compliance requirements federally imposed and imposed by the state to retain certain documents for a certain period of time. And so he would spend time when I had finalized a loan and make sure that all of the documents that I'm required to retain are in my electronic files and properly organized. So he's, by CFPB statute, he's not even allowed to see loan information that is personal information of my clients. So he can only do very, very peripheral things by law.
Okay, thank you. The employee in California, did they have any physical documents or everything was electronic?
Everything's electronic, yeah.
Okay, thank you. Just tidying up my notes.
Sure.
So we are ready to conclude this hearing. Today's hearing in the appeal of Metro Mortgage Group LLC is now adjourned and the record is closed. I will review the submitted information and will send you a written opinion of the decision within 100 days. Thank you, everyone, for attending, and that concludes our hearings for the day. Thank
Thank
you.
you.